Hello, everyone. Dennis Block with another edition of Zoom Landlord-Tenant Talk Radio. We have some ground rules that I always talk about, which is that if you do want to ask a question, very simple. All you got to do is electronically raise your hand. I see a couple of people are already doing that. And I will call on you when you are not on the air. Please leave yourself muted, which is another icon down at the bottom of your screen usually. And again, if you have an existing case with our law firm, I really don't want to talk about that. That's something that you would need to call the office on, and we're happy to discuss that. But otherwise, for general legal questions, we're going to go on for about an hour. I hope you guys are having a lot of fun doing this, because I certainly am. And don't forget, the information we're sharing here is for informational purposes only. It is not a substitute for getting quality legal help, which generally means, ladies and gentlemen, that you have to pay for it. But in any event, I want to kick off the show with some disturbing news from the city of Los Angeles with regard to income property owners. Is there any possibility, ladies and gentlemen, that there would be great news for income property owners for the city of Los Angeles? It only has to be bad news. They keep just coming at us. So let's recap. In the city of Los Angeles, because of this overreached issue dealing with the pandemic, the city stopped us from getting any rent increases from March 2020. They are now going to allow us to do this as of February 2024. Basically 4 years without an increase. And I don't know about you, ladies and gentlemen, but have you noticed that there's been something called inflation? Have you checked the price of a gallon of gas? Have you gone to a market and seen what the prices are? Or maybe have you checked out the prices that service people are charging us for our building? Not only trash pickup, but plumbers, electrician. Literally, the rates have tripled. And during this time, our wonderful elected city council and mayor has begrudgingly allowed us to get a rent increase. And they published it in their own paperwork, their eviction protection form, that said, finally, as of February 1st, 2024, we were entitled to a 7% rent increase. This is after 4 years with the rate of inflation being over for that period of time, 14, 15%. They were going to give us a whopping 7%. I thought this was terribly low. I thought this was truly unfair for anybody who's operating a building. And basically what they're trying to do, ladies and gentlemen, is make all mom and pop landowners or income property owners go out of business. But that's not what I'm talking about. The city council now has taken this up again. And they're now debating right now as we speak whether they should lower the 7% to 4%. And I guarantee you this is going to pass, that they're going to, instead of allowing us a measly 7% after 4 years without obtaining a rent increase, now they're going to drop it down to 4%. This, ladies and gentlemen, is insanity. Insanity. I tweeted about that the other day. And if anybody wants to start marching down to City Hall or writing letters to each of the city council people, please do it, because they are just coming at us. Who in life has not seen prices raised 15, 20%? They're only giving us, after 4 years of no rent increases, a 7%, and now they're talking about dropping it down to 4%. This is truly an assault on income property owners. We are housing providers, ladies and gentlemen. We give a valuable service to the community, and yet we are vilified by these people. Anyway, that's my sermon for today, ladies and gentlemen. We're going to open it up to questions now. And I see my good friend Dina. I'm going to ask you to unmute yourself and What do you have to say, Dina?
Yeah, first of all, hi, Dennis. And I can't even say enough how I appreciate your valuable time and sharing all this. And with the more that we hear the bad news, I'll go very quickly. I have two questions. I know that we check the background and the credit for the tenant when upon, applying the first time. But are we, able to do that if they are after 3 or 4 years and we want to see how their credit, do we have the right to do that?
And the answer is absolutely not. There
Oh,
is no basis of asking for a credit check once they're in. They're already in. So the concept would be, why would you need a credit check at that point in time? It would seem being more like a Snoopy Snoop. So
so
yes.
even if you want to renew for them another term, you still can't pull a credit or a background check
Well,
credit.
they can certainly authorize you to do that, but legally there's no requirement to do so.
So
Okay.
if I want to renew something for them or a term for them and I ask them and they refuse to authorize me, then that's it, right?
Right, but don't forget, if you're talking about a rent control property, which basically is every property in the state of California, you don't have the right not to renew. These tenants, once they're in, can stay there until your grandchildren have grandchildren.
Yeah,
What's
I
your
know.
second question, Dina?
Yeah. The second question I have, in an exempt property from, the rent increase and the just cause. And if you want to, let's say, increase the rent more than 10%, you're going to do a notice, you have to serve it yourself, I don't know, or through somebody else, like a process server, 90 days ahead of time saying, I want to increase it, let's say 15%. Is that upon also they have to say yes or no? And can I deliver the notice to them or process server?
Okay, first of all, if you have the right to raise the rent, or even in any jurisdiction, either below 10% or above,
Yes.
a landlord can serve that notice themselves.
Oh,
If
okay.
you serve it yourself, you have two ways to do it. You can hand
Yeah.
it to the tenant,
Yeah.
or you can mail it to the tenant. If you mail it to the tenant, I would certainly do it with a proof of mailing or certified mail where they don't have to sign for it. If you do mail it, then you have to allow an additional 5 days for mailing. So
I
if you are going to mail it, make it 35 days, actually make it 40 days. If it's 90 days, make it 100 days before, so that you're not stuck with having a bad rent increase notice. But again, the landlord can do it and a process server can do it.
and I can't ask for a return like of signature or proof of signature they sign, no?
You can, but a lot of tenants just won't sign it. So what's the
Yeah.
point? All you want to do is prove that you sent it to them. If you get
Yes.
a proof of mailing from the post office, that's actually enough.
Yeah.
Okay. All
Yeah.
right, we're going
Thank
to
you
move
so
on.
much.
Thank you. If you could unmute yourself or mute yourself, excuse me. And we're going to move on to Ryan Fitzgerald. I'm going to ask you to unmute yourself. Are you there, Ryan?
There, I think I unmuted myself, right?
There you go. Hi, Ryan.
Hi. I have a couple of questions as well. In reference to what Dina said, are those forms of the rent increase, are those on your website?
I do have a rent increase form on my website, which is evict123.com. There's in the gray buttons up towards the top, it says a free landlord forms. Click that and meander on down that list and you'll see it.
Okay. And the other question I have is, if I have like a tenant in the unit and she's got a broken window and she's running extension cords from inside the unit, outside the unit, and plugging things in, and it's tripped the breakers, what do I do? Because I want to serve her a notice that she can't do that anymore. It's like, I don't want it to catch on fire. And
Okay, well, first of all, you're talking about two different kinds of concepts here. First, you're talking about a broken window.
well, I want to serve them both at the same time that she has to fix them.
Okay, but so did your tenant break the window?
She said that a vandal threw a rock at it.
Then that means it's your responsibility, young sir. Get that window fixed on your dime, not hers. Unless you can prove that the tenant was the one who broke the window. Anybody claiming it's a vandal who ran by and threw something through the window, you can't disprove that. If you can't prove that it's her, it's your responsibility. So the first thing you're going to do is you're going to get that fixed.
Even if she has renter's insurance for vandalization?
It's your responsibility. Okay. If she wants to take advantage of her policy, she can, but it's your responsibility. You need to do it. I would do it yesterday. Let's move on to the electricity. Why would somebody run an electrical cord outside their window? It doesn't even make any sense unless they have no electricity and they're trying to grab it from a common area. So you're telling me they're taking an electric cord and passing it through the window?
Passing it through the doors and passing it through the window so she can put lights outside and so she can run cameras.
Okay, so that's an alteration of the property. You're not allowed to do that. That would be a violation of almost any contract, any rental agreement. So what you'd want to do is you'd want to serve her a 3-day notice that you've altered the property by running electrical wiring, which, by the way, is not permitted. And you're also attaching it to lighting that you hung outside the exterior of the building. So on that basis, you need to stop that, put it back within 3 days. If she doesn't, then you get the joy of bringing forth an unlawful detainer action.
Okay, and can I mail that to her with the proof of mailing?
And the answer is no. To serve a notice, you have to either hand the notice to them, or if they're not home, then you're allowed to post one on the door and mail one by regular mail. Okay, by the way, reminds me, I'm actually, because I have no life, ladies and gentlemen, this is my life. So on Sunday, the day you think I'd be doing nothing about work, I'm going to be doing a video on how to prepare and serve a 3-day notice. I will have that on my website. Hopefully I'll have it up by tomorrow if I do this well. So check in on that. It'll teach you how to properly serve a 3-day notice, which right now, unfortunately, takes a college course now to figure out how to do it based on the evilness of our elected officials trying to make landlords make mistakes.
And where will you post that?
I'm going to post that on my website. It's going to be where it says instructional videos.
Instructional videos. And
Yep.
then I have one last question.
Sure.
If you have a tenant and you want them to sign exactly the same kind of lease, because I saw that if they don't sign it, that's grounds for eviction. How long do they have to sign it? How do you have to serve that to them?
Okay, all rent control statutes have a cause for eviction, which is failing to sign a rental agreement at its renewal. But everybody misinterprets that without question. The only way that would work would be if you had a 12-month lease, and now you're in the 12th month, and you walk over to the tenant and you say, here's a new rental agreement with the same terms. Maybe I'm going to get a rent increase. But it's the same terms as the previous one. I want you to sign this again for another 1-year term. If the tenant refuses to do that, then do not take any rent in the 13th month. We would then serve a 3-day notice to perform or quit, giving him 3 days to sign and return the rental agreement. And if he doesn't, that's grounds for eviction. But what most people interpret this to be is that they have a month to month, maybe it was a lease and it ended 2 years ago. Well, now I'm giving you a new lease. It's the same thing, but it's not, ladies and gentlemen. So you cannot ask them, once that 12-month lease is over, don't let it turn into a month-to-month tenancy by accepting rent in the 13th month. Have them sign a new lease right then and there. If they don't, now it's grounds for eviction.
But how would I get them to sign it if she won't answer the door?
Well, if you serve her with, send her the lease, they sign it. We're right in the 12th month. Okay.
We are in the 12th month. Yes.
Yeah. Send her the lease. Say, this is for the start of the 2nd year. Please sign it. You don't have to see her. You don't have to talk to her. Send it to her. If she doesn't, then come.
By email, I can send it to her?
Huh?
Or no? By email?
I wouldn't do email. No, I would serve it on her. by
I'll put
mail.
it, like with the proof of
Yeah,
mailing,
that she got it. Then
and tape another one on
right.
her door.
Right. Then the following, on the beginning of the 13th month, we could then serve her with a 3-day notice. We're not going to accept rent. Serve her with a 3-day notice that you haven't signed my agreement. You got 3 days to do it. And if not, then I'm going to be contacting my friendly, good-looking eviction attorney.
So should I wait till like 3 day or like a week before the end of the month?
I would do it, yeah, about a week. Send it to her, say, please sign it if she doesn't. Maybe even give her more, give her maybe 10 days.
10 days before the end of the month.
Okay, we are going to move on. Please, if you could mute yourself, I'm going to call on Mr. David. David, please unmute yourself.
Hello.
Hi there.
Hi, thank you very much for doing the Zoom meeting. It's very helpful.
Thank you.
My question is, I have units in Long Beach. I'm under AB 1482, and one tenant has been there less than 1 year, just about 11 months. And last month he was arrested, and he's on Section 8 as well. So at the first of this month, Section 8 paid their part, but he didn't. And yesterday I went and posted a 3 days notice and 30 days to quit premises for Section 8 residents.
Right.
So my question is, if he's not going to either contact me or pay me, can I do an abandonment of premises after?
I don't think it's an
days?
abandonment because, you know, you raised a bunch of issues in this, so it's fascinating. I don't think it's an abandonment because the guy's in jail. He didn't abandon the unit. In fact, he'd love to come back. So I don't think that would be considered an abandonment. You did mention about serving a 3-day notice, 30-day notice, and I'm sure most of the people who are listening said, what the hell is that? Well, if you're Section 8, there's some crazy federal rule, if you have a Section 8 tenant, that you have to serve a special 3-day notice. It's called a 3-day notice to pay and 30-day notice to quit. So if you don't pay within the 3 days, you got 30 days notice to get out. You also have to send that 3-day notice with a couple of extra forms. They're called the WAWA forms, women, I don't even know, against violence or some silliness. Those forms also have to go, even if the person is a man. So those forms also have to be served as well. But if the tenant doesn't pay within the 3 days, even if he tries to pay you within 10 days, you don't have to accept it. And in 30 days, we can go forward with the lawsuit.
Okay, so only through eviction, regular eviction.
Yeah, I don't think you can do an abandonment for a person who's desperately wanting to come back. An abandonment is based where you have a reasonable belief that the person has truly abandoned the unit. He's got all of his stuff there. And do you know what he was arrested for?
Sexual predator.
Oh, great.
Yeah.
Great. Maybe you could give him one of my applications when you kick him out so I can get him into my building. Okay.
Okay. All right. I
Just trying
appreciate
to
it.
help,
Thank you very much.
trying to help you out there.
Thank you
All
very much. I
right.
appreciate it.
Let's move on. I'm going to go. Please mute yourself, sir. I'm going to move on to Jason. I'm going to ask Jason to unmute, and we're going to talk to him. Go ahead.
Hey, thanks so much, Dennis. So we have a little bit of an interesting situation. My wife and I started a nonprofit about 7 years ago with the sole purpose of helping to house people that were coming out of homelessness. We put a woman from Long Beach into an apartment in Huntington Beach with a contract where she would pay part of the rent and our nonprofit would cover the remainder. She is citing safety issues with the apartment that are there isn't, but effectively she's not paying. So she is our subtenant. The nonprofit holds the tenancy, and we want to remove ourselves from the apartment. So we're trying to figure out if the eviction for the tenant who is planning on suing the property management company as well as potentially the nonprofit, if we need to evict her as a subtenant, or if the landlord can do that, or what the appropriate next step is.
First of all, we live in an upside down world, and where what is logical, what is moral, what is ethical has all been thrown out the window. I'm hearing you say, Jason, that You're a nonprofit. You were assisting her with the rent, and now she's threatening to sue you. I don't know about you, but this person needs to be thrown off the closest cliff that you could possibly find. But as they always say, no good deed goes unpunished, right? So, okay, so let me ask you this question. The tenant pays you that share, and then you pay the landlord the full amount. Is that correct?
No, we pay, the nonprofit pays a portion to the property management company, and then she sends a cashier's check also to the property manager.
Are you listed as a tenant on that lease with this person?
We are listed as the tenant and she's listed as a subtenant.
And you have no real contract with her?
I mean, we yeah, formally, no. There's no tenancy contract that we have with her.
You're in a really bad situation in that in the future, what you should do is you should be the complete tenant, and then she should be with the landlord, with the owner of the property, and then you should have a rental agreement with her to pay whatever that amount is. If she doesn't pay, then you could bring forth an unlawful detainer against her. Right now, you're a sitting duck. The only one that the landlord's going to come after is you. What I would do is I would call the landlord, say, I'm done with this person. I am sorry that I put you in this situation. So what I will tell the landlord is, look, I'm gonna stop paying rent, and you're gonna need to evict me, or I'm going to give up possession of the premises right now. I'll terminate the lease. Then you have the right, Mr. Landlord, to evict this subtenant. It's an easy kind of a case to evict the subtenant for the landlord. And I would offer the landlord, look, during the pendency of this case, I'll still pay the rent because I'm on the hook. And I'll also pay the attorney to do the eviction. And then I'm done with her. And I think if you make that offer to the landlord, he'd be crazy not to take it, because otherwise, what else is he going to do? You're already saying, let's do a formal termination of the lease. I'm not there anymore, but I will be paying you rent on the side, which is legal, to cover my losses, because otherwise you'd be suing me. And also, I'm going to finance you, Mr. Landlord, to do an eviction. That's about the best I got for you. Do not do this ever again. I can tell you that. There's
No, I
better ways
appreciate it.
to do it.
We'll be reaching out to you. Actually, the property manager is my father-in-law, so he's been phenomenal as far as handling the situation.
Okay. Then that makes it a lot easier. So yeah, so you should give up the unit with a termination of the agreement. Then once that's done, then the owner can immediately start. Now, if you want to check Google, you might be able to find the nearest cliff in your neighborhood.
Thank you. I appreciate it. We'll be calling you anyway.
All right. Thanks, Guy. All right. Let's move on. I see. Please unmute yourself, and let's move on to Chris. I'm going to ask you to lower your unmute yourself.
Yes, sir. Can you hear me?
I hear you. Oh my God, I got 2 for 1.
Yeah. Bonus.
Look at that TV behind you. Very nice.
Hey, Dennis, thank you so much for doing this on a Saturday afternoon. It's really nice, and I appreciate it. Thank you so much.
I said I have no life.
Yeah, well, you're proving that today. Thank you. So I spoke with you. You were kind enough to speak to me yesterday afternoon very briefly. And I just have a little follow-up question. The situation is this. We have a female tenant. She wants her boyfriend to move in. You explained that this city of Los Angeles allows tenants to have one person move in as a guest. But what is the exact paperwork to give this guy? Because I don't want to give him an application to rent, because I don't want his name on any rental agreement whatsoever. I want his information and where he works and all that kind of stuff.
I would think a general application I would do, and I would also run a credit check. Why not?
Right.
On him.
When you say a general application, like a general rental
an application to rent, just like what you can get from any of the apartment associations, and I have one on my
your
website.
Definitely.
And then run his credit check, but I would just still make him an occupant. But if he's got bad credit, then you can say, I don't want you.
But is he going to interpret that as, oh, I'm filling out an application to rent? That means I'm going to be a renter to this guy. This guy wants.
Then cross off the word rent.
I was
Just write-
thinking about it.
just
I was
write
thinking about just cutting that
application.
part of the page
Yeah.
off and say, just fill this out.
Yeah, I see your point. I don't think that would work unless he actually gets onto the rental agreement and you authorize him. I don't think he's a tenant. He
Right.
might be an authorized occupant, but again, if that disturbs you, just write off the word rent.
Right. As I mentioned earlier, just so everyone can get an understanding, the last thing I want to do is put him on the rental agreement, because then the woman that we rented to originally, she could leave and he could stay there under rent control.
Right.
forever.
We'd be able to either evict him,
Yeah.
or we could raise the rent. Somebody's needs to mute themselves, please. And I think it's this one, mute. No, that was you. Ooh, sorry about that. Well, I think you need to unmute yourself again. Are you back?
Yes.
Sir, I'm back. Here I am.
Okay, good.
Okay, sorry about that.
So if everybody could mute themselves in here, I'm trying to find anybody who hasn't. So, oh, here's one. Yeah. So anyway, so any other questions?
So I'll just give some paperwork. It doesn't necessarily have to say rental agreement on it for him to fill out. And
No, I would just do the application, see what his situation is. Okay.
Sure. And then the tenant has already agreed to pay the additional 10%. And then a follow-up question, very quickly, as far as you mentioned something about speaking to city council members. And I'm all for that 100%. Is there any kind of pre-existing letter that's been written that we could use as a template, or just
just write saying that we have, I don't have one specifically, but I would just write and say that that this is so unfair for landlords with the amount of increases that we've had. For you now to lower it from 7% to 4% is crazy.
It's just crazy. Okay? It's like we are paying the brunt of the economic situation in our state. So anyways.
Anybody with, let me interrupt, anybody with a cell phone or they're calling, please press star mute to unmute yourself, because we're hearing background noise. So, or hang up, one of the two. Okay. All right, we're going to move on.
Thank you, Dennis.
Okay, no problem. Let's take Anastasia.
Dennis, have a question.
Anastasia.
Dennis, can I have a question, Dennis?
Okay, I'm talking to Anastasia if she's there.
Hi, yeah, I am.
Okay, talk, Anastasia.
So, I'm a property owner in Los Angeles County, or LA City, and I live in the unit. I live in the bedroom, and then I rent out two of the bedrooms. And recently, I went to the house for a different thing because my property is going to.
Let me hold on one second, because this is really disturbing to the broadcast here. I'm going to mute all right now. And let me go back to you, Anastasia. If you could unmute yourself, please.
Hi.
Okay, perfect. Yes, so I got rid of everybody. That's good. Go ahead with your question.
So I have a unit in LA City. I rent out one of the I live in one of the rooms. I rent out two of the bedrooms. Recently I went to the housing department to figure out an issue regarding, or just like figure out my rent control stuff, because my house is going to get turned into a rent controlled unit, because I'm getting the back unit, which is a garage right now, converted to an ADU. And when I went to the housing department, they basically immediately just asked me if I have a boarding permit for these two rooms, and then told me I need to get a boarding permit for the two rooms. And that right now I'm illegally renting it out because it's a single family dwelling. And I've talked to a few lawyers and nobody really seems to agree with that. And then also like not really know what to, like, they just seem to say that it is legal, but from my understanding, the city does not agree. And I had two other people, I had one other person from the city also kind of confirm that, like the rent control department. And I kind of just
the other person said it was under rent control.
The other person said that it's not legal for me to rent out rooms in the single family dwelling.
Okay. Well, there's been some case law that says that the LAHD position is correct. I'm sure these people have like locks on their bedroom doors.
They have locks that I have access to, like we all share a
But it
lock.
doesn't matter. It is considered a boarding house. There was some talk that if it was less than 5 or like 4 or less, that it wouldn't be. But the city is now declaring that to be a boarding house. So, and if it's a boarding house, you need a license. And guess what? They're not going to give you a license.
Yeah, that's what I
So-
understood.
So that's where it stands. So if there were no locks on the doors, then I think you'd be okay having 2 people there without locks on the doors. Once you put the locks on the doors, on the bedroom doors, then you're creating a separate tenancy. If you're less than 4 or less, you're okay. But if there's locks on the doors, then you're going to be considered a boarding house, and those are illegal tenancies.
What if like the locks are all shared, like we all have the same key that opens up all the same rooms? Does it matter?
If you all have the same key, I have a question for you. Why do you need a lock?
It's because we rent out the common area of the house for like events and stuff. And so we lock our doors when
Well, then why don't you put a temporary lock on when you're renting it out for events? You are a very entrepreneurish little girl, aren't you? renting out the common areas of the house. I'm renting in my rooms, and let's get that ADU going in the back.
I
But
mean,
yeah,
it's expensive to own this property.
No, believe me, I know. I
Yeah.
own a couple myself, but I would be very careful, because the tenants, if they stop paying rent, you're going to have a difficulty in evicting them, especially with more than one tenant there. So I would get the locks off the door. Then I think you're fine.
So it's literally just the locks.
Yep, that's what it is. Because if it's less than, I think it's either less than 5 or less than 4, but you only got 2, so you're fine.
Okay. Do you know what laws and like municipal codes I can look up to like understand this more?
Well, there was a case that came down, which I don't have handy, which talked about the locks on the door, and it is in the definitions of the LA ordinance, the municipal ordinance dealing with rent control, that talks about boarding house and gives a definition of what it is.
Okay. And do you know if I can get an exemption from rent control?
No, you're not going to get an exemption. No. So just take off the locks, and I think you're fine. And then do your ADU. But
right now I'm not on
but then once you build the ADU, then your house will be under rent control.
And you don't think I'm going to get an exemption from that?
No, you're going to need to register that house under rent control once that ADU gets built. So.
Tự biến mất từ qua này. Tự
Okay,
nhiên em qua đi biến mất.
okay.
If anybody, can I just say a general
Okay,
note?
Anastasia, I'm going to mute you.
Or sorry, can I just say a general note?
Sure.
If anyone has a similar situation where they rent out rooms in their house and wouldn't
Em
mind,
qua đi tìm nó.
I just want to know.
Okay,
Well,
somebody's unmute. Hold on one second. Okay.
I was just saying, if anyone has a similar situation where they rent out individual rooms in their house, I would love to.
Tôi quên cái
if
tìm.
they're
Let me
willing.
hold on. I have to mute everybody, because Jennifer is not following the rules. Let me get back down to you, Anastasia. If you could unmute Anastasia.
Yeah.
Okay, thank you.
I was just saying, if anyone has a similar situation where they are renting out rooms in their house that they occupy and wouldn't mind speaking to me, especially if it's rent control, just because I want to know more and know if it's the right decision to put this ADU in.
Well, I mean, you're going to get a lot of money for an ADU, so it's going to be a brand new structure. So I would think that you'll do much better on that. So
Yeah, just the rent control stuff sounds scary.
yeah, well, yeah, it is.
Yeah.
Okay, well, thank you very much. I want to make an announcement to everybody that unless I call on you, I want you muted, because it's really disturbing to the host, that would be me, and everybody else, because nobody can hear the questions. Okay, so please mute yourself if you can. I'm going to call on now. Pamela, I'll ask you to unmute. And hi there, how are you?
I'm well, thank you. How are you?
I'm good, thank you.
Good. Thank you for doing this. We received an eviction that you got for us. And how do we put the eviction on that person's credit?
Well, let me ask, well, I don't like talking about specific cases, but do you already have a judgment?
Yes,
Okay, has the tenant already been evicted?
yes.
So they have this crazy rule. Well, it's not crazy. It's just totally lopsided for landlords that all eviction cases basically are hidden. They're masked. So if anybody looks up to see if Joe Smith was ever evicted, it won't show. If I gave you his case number and you looked it up on the court docket, it would show nothing found. Because unless you get a judgment within 60 days, then the case by law is considered masked. Well, right now, with the delays of the court and tenants filing motion and trial dates, you're never going to get a judgment within 60 days in most cases, unless it goes straight by default. So any contested case is going to take longer than 60 days. And on that basis, his record's going to be sealed. So the guy who's really bad, his record is sealed so that nobody else can know. Depending on what kind of a case it was, you can file a motion and go into court to get the record unsealed because he was considered guilty of unlawfully detaining the premises. So you might want to check with my office on what's involved in doing that.
Okay. And then just another thing, and I don't know if I missed it in the beginning, but I heard on the radio that the rent increases that we might be allowed to do in February won't start for another 6 months.
That is untrue. They are going to allow rent increases come February 1st. The fight now is whether they were going to give us a lousy 7% or an insulting 4%, which is what they're voting on now.
Oh, okay. Because I know that they said 7%. That's what I was looking forward to.
You got it. Okay, let's move on. I'm going to move on to Marissa. Please mute yourself. And Marissa, say hello.
Hi, Dennis. Hold on one second.
Marissa, are you there?
Hi, Dennis. Can you hear me?
Hi.
Hi. Okay, so I had a question. I was referred to you by another attorney. It's very, what I've been finding in my experience thus far is that it's very difficult to find landlord attorneys as opposed to like tenant attorneys. But anyway,
Hi, I'm easy to find. Look at me.
Yeah,
I'm right here.
you are easy to find, and I'm so glad. I just so happened to like Google you, and I saw that you were doing this. So, and it literally was just, it was like 3 p.m. and I jumped on immediately. So thank you so much for hosting this today. I'm actually dealing with a tenant. So I'm a first-time landlord. I have a tenant. I decided to go the Section 8 route just due to what I was experiencing when I was in the process of purchasing, and the fact that, you know, all these, with the eviction moratorium and stuff like that. And so I figured it would be easier because it was stable, more stable income.
That is
So
true.
yeah, so I have a tenant who has been a nightmare. She was a tenant who was referred to me by the head of LACDA actually, and they expedited her profile because the head of Section 8, Medina Johnson, was in touch with someone from DCBA, Tyler Cash. And so I guess like through Tyler Cash, that's how she was able to get her Section 8 voucher. And then they worked together, both Medina and Tyler expedited her case for me. And so, you know, I did my research on her. Like, everything was good. Her credit was decent. It was like above a 680. And also I had spoke to her landlord before, because that was kind of alerting to me, the fact that they were like expediting this, but it wasn't like she was homeless, but they were saying they were trying to prevent homelessness with her and her family. So I spoke to her last landlord, and he was saying, you know, she always paid her rent on time, which, to be fair, that is the case. In fact, she always pays her rent early. The issue that I'm having with her is that she is very confrontational, and it's become increasingly hard to communicate with her. And this didn't happen until the first time I told her no. So she asked me if she could add her niece onto, if she could take her niece in and have her niece live with her. And I told her no, because I told her, you know, she has a family of 6 already, and it's only a 3-bedroom. And then I also told her, you know, it was a violation of her Section 8.
Section 8 agreement, correct.
Exactly. And she was saying that they would override that. But it came down to me giving permission, and my answer to her was no. And so that turned into like a huge argument. And so now I just like, okay, I need to lawyer up, because her thing is, and I don't know if this information she's getting through DCBA or what, but she keeps threatening the fact that I have to pay her relocation assistance. And I'm like, well, you're not being evicted, so therefore there's no reason for relocation. And I asked her, like, do you want to break your lease? And she's like, no. Her thing is she wants to stay there for 3 years because she wants to buy a house eventually. And I'm like, as long as you follow all of the policies in your lease agreement, there is no issue. But every time she has a maintenance request, I'm just jumping through all these hurdles. And then I've asked her, because there are some utilities that I'm responsible for. And so she'll come to me with a maintenance request, and I'm doing everything that I can to resolve it immediately. But then she'll contact the carrier, and it's like, first of all, you're not authorized to be contacting the utility companies that are in our business account. And it's kind of fraud, because you're giving them my information to do that. So
I got to slow you down, Marissa, because we're going pretty long with this story. Obviously, you don't have to allow an unauthorized person to move into the unit. You can just turn a deaf ear to her with that request. Obviously, that if there's a maintenance request, that should always go through the landlord. There might be a provision, I know it's in my rental agreement, that states specifically that all repair requests must be in writing and come to the landlord only. But obviously, you got yourself a difficult tenant. The best thing to do is to ignore her, and just to, if something legitimately needs to be fixed, serve an access notice and go in there and fix it. I would send her a note specifically stating that you have no right to contact any other party. Now, maybe for utilities, if you have a gas leak or something, I think it's not improper for the tenant to call the gas company, hey, I got a problem here. But other than something like that, then all repair requests should go through the landlord. But stick to your guns. Make her follow the terms of the agreement. If you find that she actually brought that person in, then you certainly have the right to bring forth an eviction on that basis.
Okay, well, can I ask you this more specifically? So on Tuesday, she contacted me and said that the propane tank was empty. And so, and that it needed to be.
The propane tank was what, please?
Was empty and needed to be refilled.
Okay, what do you have a propane tank for?
Like for her gas, and the only thing that runs off of the gas is the wall heaters.
Okay, so you have propane wall heaters?
Yes.
Okay,
and
no, I haven't heard that one, but it's a big world.
Yeah.
But I guess you have to fill them.
Yes.
Okay.
And so I put in the request immediately, and I've been asking her questions like, hey, like, well, up to when was it not working? And she's so difficult that she's not answering these questions.
But why do you care when it was not working?
Well,
let me finish the sentence. Why do you care if it's not working, if all you need to do is to say, okay, it's empty, I'll fill it?
Right. So I did that, and I put in the request. The problem is the gas company is saying that it will take up to 15 days for them to come out based on their delivery schedule. So I've paid $100 extra to have them expedited. And now they're saying they won't be able to come. Either the earliest they could come is Monday, the latest they could come is Wednesday. But my issue is, like, she's contacting HUD, and she's CCing HUD and Tyler Cash and all these.
And she has the right to do that, ma'am. She can call anybody she wants. She can call me. She can call the president. She can call anybody she likes. That doesn't mean that you have to be upset because she's calling. You're acting and it's very odd what you're telling me about a propane heater that the gas company is the only one who can fill. But okay, I'll take that as what the issue is in your building. But you're acting as reasonably as you can. As soon as you heard that there was an issue, you reached out, you even paid an expedited fee. That's it. There's nothing more for you to do. If in fact she's complaining to different organizations, let her complain. You haven't done anything wrong. We're going to move on, Marissa, but thank you for that. And I'm going to move on now to, let's take Janet Ruiz. If you can, I'll ask you to unmute yourself.
Hey Dennis, how are you? Thanks,
Fine.
thanks for doing this. We got actually recommended to you by Randall, Rich Randall. So we're excited to chat.
Oh, sure.
So the short of it is, I bought a house Highland Park about 8 years ago, and it came with a tenant. She was we created a new rental agreement, just her on it. A couple months ago, we were getting ready to sell the house, and we started doing a chunk of work. It's a duplex in Highland Park, and basically in doing the work on the house, we started to notice that it was more than just her living there. And we have a ring camera as well, and it looks like her son is living there. And so we served them a 15-day notice, which Rich said to do, and say fix or repair or leave.
Oh, wait,
And
I'm
basically,
curious. Let me stop you. You said fix or repair.
yeah, like
I don't
to
understand. What does that have to do with an extra person living there?
because he's not on the lease, it's just her.
But you said the words fix and repair. Fix and repair what?
That she
Just-
actually broke the rental agreement because she
Okay,
has her.
all right. So you're using unusual language. Okay, what you're saying is that they violated the contract because this, I presume, it's an adult son.
Yeah, he's like in his 30s.
Okay, is living there, right? So what? It wouldn't be a 15-day notice. It would be a 3-day notice to perform or quit, giving him 3 days to vacate. And when he doesn't, then you have the right to evict everyone from the house. Is this a
Okay.
single-family home?
It's a duplex.
Okay, so you're under statewide rent control.
Yeah, we live in one side, they live in the other.
Right. Well, then you would know that this person's living there, right?
And they responded actually with a response saying that he's already established residency. He talked to the LA housing people, and they
Yeah.
told him he's already established residency, and that
he could-
was here before us, I guess.
He could talk to God. He has not established residency. So I don't care what phony person he talked to, or maybe some unknowledgeable person. That's in violation of the rental agreement. You've asked him to leave. He doesn't want to leave. We serve a 3-day notice and we proceed forward with an eviction. In fact, I did one of those cases just today.
Oh, wow.
Do you want to do another
Yeah,
one?
you want to
Yeah,
do
we have
another
room.
one?
Call me Monday.
Okay,
Okay.
fantastic. Thank you so much. for doing this.
1-800-77-EVICT.
Should we write them another, like, the 3-day additional warning or anything? Because it's been the 15
No, let's just
days.
serve the notice. Let's go forward.
Okay.
Okay.
And should we be cashing their rent checks?
Oh, good question. No, do not accept any further rent ever.
Okay.
All right.
All righty.
Please mute yourself if you'd be so kind. I'm going to move on to Diana
Thank you.
Delaney here.
Yes.
Hi.
Hi, Dennis. I spoke to you this morning. Thank you. Dennis, I had 3 questions, if I could do 3, if not 2. We have some old properties that have had very low rent, and now I know we have this window of time to crank up the rent, and we have some huge expenses with roofs, like you mentioned. I mean, they have like tripled and quadrupled in price, and so is like doubling the rent. Like if I have people paying $1,200 and $1,300 for a single family residence in the city of Los Angeles, can I crank it up to 22, 23, 24, which is still under market by the rent-a-meter stuff, or am I going to get myself into problems doing that?
A single family home or
Yes.
a townhouse or a condominium is not subject to any rent limitations based on state law. On that basis, you can raise the rent as much as you like, whenever you like. And if you're going to increase the rent more than 10%, it's a 90-day notice. If you're going to increase the rent 10% or less, it's a 30. But the city of Los Angeles, which is where your property is, has this incredible economic displacement relocation requirement that if you raise the rent more than 10%, the tenant can say, okay, I'm out of here and I'm going to ask for my relocation. Relocation for a single family home is only 1 month's rent. but you might be stuck with that. That particular law is under judicial review. There's a lawsuit against the city filed by the Apartment Association of Greater Los Angeles. So we're seeing how that works out, but the tenant could potentially, I don't think it's a big deal, but the tenant could potentially say, I'm not going to accept your rent increase and I want you out. And I want out and I want my relocation money.
Well, if it was 1 month, we'd be happy, but I was reading on that renter protection notice, and it says that if a landlord is a natural person who owns no more than 4 residential units. So we have a few.
You're reading that wrong. Under the economic displacement, which I'm pulling up right here, for a single family home, it's 1 month's rent, period. I can tell you though that if you have a building that's not subject to rent control, let's say like a multi-unit building, but it's not subject to rent control, let's pretend it's brand new and you raise the rent 20%. For a 3-bedroom, you'd have to pay the guy $10,075. But for a single family home, it's 1 month's rent. Now that's true of condos. You'd have to pay if it was a 3-bedroom, you'd have to pay $10,000. But for a single family home, it's only 1 month's rent.
Okay, because I was reading that relo thing and it kind of freaked me out because it said for a qualified tenant, they could go up to that was there over 3 years. They could go to.
Well, again, we're talking about a specific thing where you serve a rent increase notice above 10% and the tenant states, I don't want to pay that, I'm leaving, where's my relocation money? There are different charts, which is I think what you're looking at. You're looking at the wrong chart. So if you don't, you can go as high as you want, and if the tenant doesn't want to get it, then you got to throw at them 1 month's rent.
Okay, well, we can only pray that they'll leave. The other question, Dennis, is that if we wanted to sell, so that's where I guess, I'm getting that. We have some properties with different levels of title. So like I'm a third on a couple of properties. I mean, does that one that I'm talking about that has that the natural person can only own up to 4 units? Is that where that
you're talking about AB 1482, which talks about something to that effect where actually, I don't even think you're talking about AB 1482. The bottom line is for a single family home, for a townhouse, or for a condominium, you have the right to raise the rent as much as you like, whenever you like. It's a law called Costa-Hawkins. This law starts with the following statement. And here's the way the law starts. Notwithstanding any other law, you have the right to raise the level to whatever you like for a condo, single family home, or a townhouse. That's the way that law is. That law is still on the books. However, they have a thing on the ballot that's going to be November of 2024, which is going to try to take away Costa-Hawkins. Costa-Hawkins states that as one principle. Costa-Hawkins law also states that if your unit is vacated, the tenant says, I'm gone, goodbye. They could, right now, you can raise the rent to whatever amount you like. That makes sense. The place is vacant. I'm going to get whatever I want for it. Costa-Hawkins ensures that. They're trying to take away Costa-Hawkins. You've got to vote against this moronic law, which has already been on the ballot twice and lost. This time they called it, as I'm looking, justice for renters. Can you imagine? Justice for renters. It's theft and murder of landlords is what they should call it. So make sure that we vote against it. We've got just a few more minutes, so I do want to move on. Thank you so much. I'm going to move on.
Can I have a question, Dennis? Can I have a question?
Remember, you have to be called on, darling. Remember?
Too long. I've been waiting too long.
I know, but other people are waiting. So
is that okay?
To follow the rules. I'm muting you. I'm sorry, darling. Let's move on to Janice. I'm going to lower your hand.
Thanks for doing this, Dennis. My question is about greening up the security deposit. Twice in the past 5 years, I've had tenants who did a lot of damage mid-lease, and there was pushback from property managers about getting it fixed when repairs had to be done right away. It's like, oh, deal with it, either do the repairs, which if they're necessary, and take it out of the security deposit. My understanding is that they have something that damage they caused that needs to be fixed immediately for operational reasons or safety reasons, needs to be billed to them mid-lease to green up the deposit. Is that right?
I do, that's not incorrect, but I do it in a different way. Most rental agreements say that if a tenant negligently damages something, that he is responsible for the repair. So what I would do, having nothing to do with the security deposit, I repair it. You broke the window. Here's the bill. I'll give you 7 days to pay it. When they don't pay it, I'm going to serve them with a 3-day notice to perform or quit, giving them 3 days to pay that repair bill. If they don't, then I'm going to evict them.
What if I don't want to evict them? You don't think the
Well,
other
then
thing?
you can go to small claims court. Okay. But I mean, what difference does it make? You've already got the security deposit in your pocket. Okay. So
Right.
what you're going to do is you're going to peel off $200 of that security deposit that's in your right pocket, and you're going to take the $200 and stick it into your left pocket. What difference does it make?
No, these are cases where the property manager let it go on, where the damage caused far exceeded the security deposit in the case of two different
Right.
tenants.
So you can either sue the tenant in small claims, forget the security deposit, keep that in your pocket. You can
Right.
sue the tenant if you don't want him to leave in small claims court and go through that dance and then try to collect on it. Right. So,
Okay.
all right, let's move on to Mel. I'm going to ask you to unmute. Hello, Mel.
Hi, Dennis. Hi.
Hello.
So I own a duplex under rent control in LA. The sewer line there has some cracks and gets clogged by tree roots about twice a year. So
I'm sorry, you said trees clog the pipes? The roots?
Yes, it's tree roots. Yes.
Yes.
So the tenant just called me a few minutes ago. They always do. About it, and my plumber can come and fix it on Monday. I'm wondering how much time I have to get it fixed once the tenant calls.
Okay, well, I mean, you have to do everything in an expedited, reasonable fashion. I mean, sometimes when an elevator breaks in a building and it takes, 3 months to get 3 parts, there's nothing else that you can do. But if you can get somebody there within a day, then you really should. Right now, he can't use water. What's the symptom?
No, I guess the sewer line is kind of leaking or something. It's clogged, but they can use the water.
Well, where is it
toilet and
leaking?
everything.
Leaking where?
From side of the building.
Okay, so it's leaking on
from
the side of the building.
balcony.
It's not intruding into their unit. So I would think you'd be
No.
okay with that. I'm
Okay.
going to take one more call, and I'm going to try to find me, whoever she was. It said Emmy. There you are. I'm going to ask you to unmute. See, you waited your turn, and I'm ready to talk to you. Me, Emmy. There you go. See, you got
Hi.
in.
Hi, Dennis.
Hello,
Hi.
darling, my little
This is
pushy
me.
character. And I know why you're muted, so I can't see you, but that's okay.
I'm one of you, Brian. I have several cases with you. You are my angel, help me a lot. And I have a question. I have some property that not under rent control, which is single family home. Do I have to send them a notice say that, oh, my property is not under rent control? Do I have to send that out?
Okay, first of all, what city are we talking about?
One is in Sunland, California, is near La Cañada, La Crescenta.
Sunland is Los Angeles. Go ahead. The next one
is Rancho Cucamonga. The
Okay.
second.
So
And the third one is in Lake Elsinore.
Is where?
Lake Elsinore.
Oh, Lake Elsinore. Okay. Well, actually, for all three, if the rental agreement was entered into in, I believe it's July of 2020, you had to have that phrase in the rental agreement. If it wasn't, then technically you are subject to statewide rent control. You are not subject to rent limitations if these are houses, condominiums, or townhouses. Now, if the property was leased prior to July of 2020, then you can serve just a notice that this property is exempt, not where they have to sign for it, just like
Got
you
it.
do a rent increase notice. So you would send those, but that's only for tenancies that were initiated prior to July of 2020. Anything that became, or even if you renew a contract, it's got to be in the contract that, hey, this property is exempt from statewide rent control. And
Yes.
by being exempt from statewide rent control, they have to sign that. And obviously, you would not be subject to good cause to eviction.
Got it.
I'm going to take one more
Yeah.
call.
Thank you, Dennis. Appreciate it. Thank you.
All right. I love you. Is there anybody else?
Love
Oh,
you
I see one more. Well, I'm going to go around again. Let's go to Ryan Fitzgerald, and you'll be my last caller. Love you. How can I help you?
Okay, so once you do the 3-day notice, then how do you prove that they haven't made the alteration or cured what you've asked them to cure?
Well, for example, if they have something on the outside of the building, you know, like where I think your issue was that they had an electrical line going out to surveillance cameras. That's simple to prove. You walk over there, you look up with your 2 eyes, and you make a mental note. Can you also take a picture of it? Yes. But your eyes are there is fine proof. People
There
always,
wouldn't be my word against her saying like, oh, I removed it.
well, of course it would. However, this is something fixed. You could just take a picture of it.
Right.
You
And
know?
then let's say on day 6 she removes it, but I want her out. So
well, but on day 6, what you served was a 3-day notice, correct?
that's what I'm going to look on your website.
Right. But you didn't serve a 3-day notice plus whatever the hell I feel like. You served a 3-day notice. If it's there on the 4th day, I don't care that she removes it on the 5th day or the 6th day. If it was there on the 4th day, so you take a picture on the 4th day, or you note it with a friend that, hey, see that camera up there? So
Okay. And
anyway, I
then,
want to thank everybody. I always
can I ask
enjoy
one
doing
more-
this. What?
Can I have one more question?
One last question, then I'm going to cancel it out. Go ahead.
Okay. Well, it has to do with that too. So, oh God, no, I forgot it. Sorry.
All right, Ryan, I'm gonna let you go. Everybody, thank you for joining. This is a weekly thing every Saturday at 3 o'clock. Come on in and tell your friends, because I want to build this up to over 100 people. I see that people are doing chats. We really don't do chats because this is kind of a one-man show where I do the board all by myself, so it's hard to get into the chat. So, but in any event, everybody we're finished, young lady. Everybody have a great day. If you need me, you can call me at the office, and I'm happy to talk to you along with my other tenants, my other associates. We only have about 25 of them at the office, so we're happy to assist. Anyway, thank you very much, and I'm signing off. Dennis Block. Have a good day.